Hi everybody, I'm going to be giving a brief update on certain of the recent changes in employment tax. And I think it's fair to say the last year has seen a number of such changes, some of which are supposed to simplify matters, although they seldom do, and some of which are supposed to basically are aimed at curbing what HMRC and the government see as arrangements which are kind of motivated by tax or NIC avoidance purposes. And I think it's fair to say that it's been quite difficult to keep a handle on all the various proposals and changes because they seem to have moved around an awful lot in both consultation and draft legislation stages. And it's not been made any easier by the fact that a lot of the legislation that was supposed to be introduced in this year's Finance Act was actually bumped out in order to allow the Finance Act to be passed quickly before Parliament dissolved in advance of the general election. Although most of the legislation that was included in that Finance Act that was kind of removed is expected to be reintroduced as soon as Parliament comes back in after the general election itself. On top of that, I think there's been an increasing uncertainty from both an employment law and a tax perspective in relation to employment status, in particular with regard to the gig economy, and that's culminated in a number of high-profile cases, at least in the employment law sphere, which will inevitably have an impact on kind of employment tax matters. And we've also had the introduction of the off-payroll working rules in the public sector, and obviously there's uncertainty there as to whether or not there's going to be an extension of those rules to the private sector ultimately. So today I'm going to just focus principally on those areas where we do have some certainty as to how the rules are likely to work. Although, as I've said, only in one of those areas, so salary sacrifice, do we actually have any rules actually in place at the moment as enacted earlier this year. I'm firstly going to look at termination payments and at the changes which are going to be made to the tax treatment of termination payments as from April 2018. And the government initially claimed that these changes were supposed to be aimed at simplifying the tax treatment of termination payments, although they have now conceded they are actually intended to clarify and tighten the tax treatment of termination payments. And just before looking at the new rules that are going to be brought in, I thought it would be worthwhile just to clarify some salient points in relation to the existing position. So that, as you'll be aware, under the current rules, payments which are made in connection with termination are usually taxed under Section 401 and Section 403 of ITPA, which basically allow the first £30,000 of such payments to be made tax-free. You also basically can also pay any termination payments without having to account for employer or employee national insurance contributions. And at the moment we have a different treatment between contractual and non-contractual pylons. So if you have a payment which is made under a contractual payment in lieu of notice clause, then that's going to be taxed in full and subject to NICs in full as a general earnings. But if you can structure matters so that where you have no contractual pylon, you basically terminate the contract in breach of any notice period and make a payment as damages for breach of that contract, then you can usually make sure that that payment falls within Section 401 and 403 and take advantage of the £30,000 exemption. At the moment, we've also got some uncertainty in relation to payments which are made on termination for injury to feelings, say as a result of discrimination. So at the moment, there is an exemption for any payments made on termination which arise as a result of injury or disability. There's some case law which says that that does not extend to payments for injury to feelings, but it's far from certain at the moment as to what the position is. And it's still open to argument that such payments should be able to take advantage of the exemption. And finally, in certain circumstances, a termination payment can possibly be made completely or partially tax-free if it can be made in respect of what the employee has, where the employee has actually had foreign service, so where they've performed duties outside the UK and where they've been not subject to UK tax in respect of those duties as part of their service with So following a very lengthy consultation process where the government initially proposed some very far-reaching changes to the tax treatment of termination payments, which were, I think it's fair to say, almost universally criticised as being far too onerous and complicated, the changes that are going to be introduced are more restrictive, and they're broadly as follows. The £30,000 threshold, either £30,000 exemption for Section 403 termination payments, is going to be maintained, but the Treasury do now have a power to vary that threshold by regulation, and it remains to be seen whether or not that variation will be up or down. I think, as Tom has already mentioned to you, it's also going to be the case that Class 1A NICs, so employer-only NICs, will now be payable on all termination payments which are in excess of the £30,000 threshold. So now you'll have to pay both income tax and employer Class 1A NICs on amounts above the 30,000 limit. And probably the most controversial of all of the amendments is that provisions are going to be put in place to ensure that all payments which are made in lieu of kind of notice are going to be treated as general earnings and subject to income tax and Class 1 NICs, so employer and employee NICs, as if they were just normal payments under the contract. And this is going to be the case whether or not such payments are contractual or not. So even in a situation where you effectively terminate a contract without giving notice, in breach of notice provisions, any payment that could potentially be related to the pay that the employee would otherwise have got during that notice period will now be taxable as earnings. And I'm going to come on in a minute to look at how you calculate that amount when you're doing your kind of assessment as to what's taxable and what isn't. Just a couple of further changes. It's going to be made absolutely clear that payments for injury to feelings fall outside the exemption for injury or disability unless they amount to a psychiatric injury or a recognised medical condition. So where you might previously have tried to claim that part of a termination payment related to injury to feelings as a result of, say, discrimination arising as a result of the termination, then you can no longer argue that that falls within the exemption for injury unless you can get a clear medical diagnosis that there's a clear kind of psychiatric effect. It's worth noting, however, that doesn't prevent you still arguing that any payments that you make as a result of potential discrimination pre-termination, so discrimination in the employment itself, you can still, in that respect, try and argue that those payments are injury to feelings and fall within various other exemptions and are not taxable at all. And finally, the intention is to abolish the Foreign Service exemption, except in relation to seafarers. We don't have any more details on this because the legislation in that respect is not actually being drafted yet. The Revenue have said they are going to still try and keep some kind of territorial limitation on the extent to which termination payments are taxable, but that's very much a watch this space. And as I mentioned, all these rules are effective from the 6th of April 2018, and I've put in brackets probably, and that's because this is one of the areas where the rules were actually taken out of the Finance Act. So they are not actually in force at the moment, but the expectation is that they will be brought into force in a new Finance Act as soon as Parliament comes back after the general election, and my suspicion will be that will be whether or not we have a Conservative, Labour or a hung government. So just coming back briefly to the new treatment of payments in lieu of notice and how you calculate what amounts are now taxable as general earnings. What happens is that the legislation now effectively splits termination payments between amounts which still fall within Section 403, so you can apply the £30,000 exemption, and payments which now fall within a new Section 402B. And any amount of the termination award which does fall within the new Section 402B is going to be taxed as if it's just general earnings from the employment. So what you have to do is you have to look at the actual amount of the termination payment, take off any amounts which are payable in respect to statutory redundancy payments, and then when you've got that, you can it's only amounts which exceed the post-employment notice pay which can still fall within Section 403. So you have to look at what is post-employment notice pay. And broadly, what you need to do is you need to look at the basic pay that that employee would have received had they gone on to work their notice period, or any notice period that they would have had in the contract if it hadn't been terminated, kind of without the notice period being worked. And that amount, regardless of how you pay it and regardless of how you try and characterise it in the settlement agreement, is now going to be taxed as general earnings. And when you're looking at basic pay, you basically have to look at the employment income that that employee would have been entitled to in the last pay period prior to the trigger date, which is essentially the date they leave employment. And with that, you're really just looking at their basic salary. You're not including things like overtime, bonus or commission. Any benefits aren't included, and amounts that might be received in respect of shares or share options are not included either. And then you take that basic pay and you effectively extrapolate it over what would have been the notice period. So just a brief example, you've got an employee who is paid £7,000 monthly, so that's their basic pay, and they have a 3-month notice period. Their employment is terminated without notice. The employer makes a termination payment of £35,000 and the contract didn't provide for a contractual pile-on. So under the current rules, you could argue that the full amount of that £35,000 was being payable as a termination payment, effectively because the employer had breached the notice requirements in the contract. But now what you're going to have to look at is you're going to have to work out what is the post-employment notice pay, i.e. what would they have been entitled to receive had they continued to work out the notice period. And in this case, that's broadly going to be about £21,000, so £7,000 for the next 3 months. So that amount is going to be taxable as general earnings, and it's only the balance of the £14,000 which is going to continue to be taxable as a termination payment. Now, as you can see from that quite simple example, I'm not sure that anyone is going to say that the tax treatment of termination payments has got any simpler. In particular, I think it's going to result in some quite complicated calculations, even in pretty kind of basic scenarios. And obviously it's going to result in more tax and NICs being paid. So the second area I wanted just to look at is the changes that are going to be made to the rules relating to salary sacrifice arrangements. And I think it's fair to say that the revenue have been unhappy with salary sacrifice arrangements for a while now. Although there are a number of non-tax reasons why you might want to implement salary sacrifice arrangements, a lot of the drivers are broadly tax and in particular NIC savings, and I think it's just starting to cost the Exchequer way too much money. So just to very briefly recap on how salary sacrifice works, broadly the employee gives up part of his or her entitlement to salary or bonus, which is subject to income tax and NICs in the normal way, and in exchange for that they receive a new or an enhanced non-cash benefit which benefits from either a full or a partial exemption from tax or NICs or both. So for example, an employee might give up some salary in return for their employer making a payment into their pension, which would save on NICs, or in return for receiving childcare vouchers, which would save income tax and NICs. And in order to successfully implement a salary sacrifice arrangement, you have to do a number of things correctly. So you have to properly vary the employment contract. The employee has to give up their right to salary for a certain period of time. They can't simply elect to switch back to receive the salary and give up the non-cash benefit. And usually such schemes require employees to elect in or out for certain periods of time, normally kind of 12 months. The sacrifice has got to occur before the employee is entitled to receive the remuneration under the original contract. And there are also a number of other issues that need to be considered both by the employer and the employee before deciding whether or not salary sacrifice is something that you should be doing. So the question is, with the new rules that are to be implemented, is salary sacrifice arrangements still possible? Well, the answer is yes, it is, but only for a very restricted list of benefits. So it's only the benefits on the slide which can now be the subject of salary sacrifice arrangements which attract beneficial tax and NIC treatment. So now the only benefits which can be subject to beneficial salary sacrifice are employer contributions to registered pension schemes, pensions advice, employer-supported childcare, cycle to work schemes and schemes in relation to very ultra low emission cars. There's still some debate about whether or not salary sacrifice arrangements in return for intangible benefits, so benefits such as extra annual leave or flexible working hours, do now work. And this is, as I said, still up in the air because the Revenue indicated in their initial consultation document that they weren't intending to target such schemes, so such schemes would still be available, but the legislation in theory is wide enough to capture them, and the Revenue haven't issued anything recently which in their draft guidance which actually confirms the position. So you do need to be very careful when you're looking at arrangements with employees that you don't inadvertently fall foul of the new rules, because they are very, very widely drafted. So the new rules are going to apply to what are known as optional remuneration arrangements. So any arrangements where the employee gives up a right or a future right to receive an amount of earnings in return for a benefit, or where they opt for a benefit when otherwise they could opt for some kind of cash allowance. And it can also apply to pre-employment arrangements. So you can't try and argue that because you've agreed with an employee before they enter into employment that they'll get a benefit rather than cash, that it's not a salary sacrifice because they never had any salary to actually sacrifice. It's made quite clear in the legislation that those kind of arrangements that are going to be caught. And where you are caught, so where you do have an optional remuneration arrangement which is not in respect of one of the acceptable benefits, then you're going to have to be taxed on the value of the benefit. And the taxable value is going to be the greater of either the salary or the cash allowance that's been sacrificed, and the cash value of that benefit calculated in the normal way. Although it is, you do need to be careful there because the rules in that respect are also slightly varied. And as expected, where you have a taxable benefit, you will also have to pay Class 1A NICs in respect of that taxable value. These rules were actually included in the Finance Act, unsurprisingly, and they came into force on the 6th of April this year, but there is grandfathering arrangements in place for salary sacrifice schemes which were already kind of effectively entered into as at 6th of April. So if you do have existing salary sacrifice schemes, they will actually be okay up until broadly 6th of April next year. Where you have salary sacrifice arrangements over cars, accommodation and in respect of school fees, then they're broadly okay until 6th of April 2021. But you will need to start thinking about what you're going to do in relation to any salary sacrifice arrangements that you've got in place over other benefits. And also, if you need to be very careful if you do have an existing salary sacrifice arrangement that you don't do anything to vary it broadly before the 6th of April 2018 or 21 as applicable, because if you do vary it, you can quite easily take it outside the grandfathering rules, and then you find that you've had a salary sacrifice, but you do still have taxable benefits, even in relation to existing schemes. And the last area I just wanted to make you aware of, which is actually a new and helpful relief, which is to be introduced effectively where the employer is looking at meeting the costs of legal advice being given to employees, where those employees are involved in proceedings, processes or investigations relating to the employment. So essentially it's now going to be possible for employers to pay to meet the legal expenses of employees where those employees are having to kind of provide evidence or take part in say an FCA investigation without incurring a benefit in kind charge where you've met the legal expenses. So broadly, the new relief allows you to pay the legal costs and expenses, or also premiums under qualifying insurance contracts, which are incurred in connection with either former or existing employees, where those employees are either given evidence or otherwise connected or kind of involved in any proceedings, processes or investigations which relate to their employment, their acts or other matters relating to their employment. And that can be that is very widely drafted, so it can include civil, criminal or arbitration proceedings. It can include disciplinary and regulatory proceedings as well. And so that's going to be quite helpful because at the moment there is a concern that where you do seek to cover kind of employee legal costs, then they will actually suffer a tax charge on that kind of reimbursement. And that is effective for tax years 2017-18 onwards, so essentially from 6th of April this year. Again, probably because it hasn't been enacted yet, so that's not that helpful, but I suspect, again, this is one that will go through as soon as Parliament comes back in the summer, so hopefully it will be available as from 6th of April this year. There are obviously other issues that are very current at the moment. I mean, as I said before, there's off-payroll working. Will that be extended to the private sector? There's employment status. What's going to happen with that, both from an employment law and a tax perspective? There are still issues in relation to clawback. You know, what happens when an individual is required to pay amounts back? Can they get a tax relief for that? On none of those questions do we have any certainty really at the moment. So they're probably areas where we will hopefully be able to give you a bit more of a firm view in future seminars.